Hello. Well, thank you all for joining. I'll give you a few more minutes. Melissa, let me know when I should start.
Awesome. Hello and welcome to everyone. Welcome to our National 8A Association webinar. My name's Haley Bingham. I'm the Deputy Director of the National 8A Association. And we are excited to have our speakers today, John Klein and Mark Hagedorn with the U.S. Small Business Administration. Please join me in welcoming them as they provide updates on the 8A program in light of the Ultima decision. Kick it off to you, John.
Thanks, Haley. So as you all know, you've heard about this decision already. On July 19th, the Eastern District Court of Tennessee enjoined SBA from using the presumption of social disadvantage in administering the 8A program. So they didn't say in entering the program, they didn't say in terms of applications, they said in administering the 8A program. So that's what the injunction says, and that's where we are right now. There'll be a hearing on August 31st to further define the remedies that are going to be involved. But until then, the injunction says what it says, and we have to abide by the injunction today. That doesn't mean that we won't appeal, or that doesn't mean that this is the final resolution of the issues. But right now, we are where we are, and we have to abide by the injunction again. So what does the injunction actually require? So for new applications, any new individually owned firm will have to demonstrate social disadvantage as part of the application process. The decision will not affect entity-owned firms applying to the program. Those questions will be the same as they have been before. But for new applications, that will change. It applies also to contract awards. I'll get into this a little bit further. Again, does not apply to entity-owned firms, ANCs, tribes, NHOs, CDCs. And the injunction also does not apply to individuals who previously demonstrated their personal social disadvantage. So if you were a woman or disabled or another non-group member that individually demonstrated your personal social disadvantage, you are not covered by the injunction as well. So our new applications, where are we with that? As you all know, there's currently a pause on the receipt of new 8A applications. And this is across the board. So even though entity-owned firms are not affected in the application process, unfortunately, the system that we have right now is tied, they're all tied together. So it's either on for all or off for all. So right now, it is off for all until we develop new questions that will be available for all individually owned firms. As I said, we are developing these new questions, and they're designed to give better guidance on what is necessary to establish social disadvantage. And we will have within those questions or in the prompts surrounding the questions, examples of what types of statements meet the requirements and what types of statements do not meet those requirements. So it's important for you to look at those as you go through the process, because you will have to go to meet the burden. So the questions for all individually owned firms will change based upon the new questions that we're developing. And they will be the same for all individuals, whether you are a former group member or not. The questions going forward will be identical. And again, the questions for the entity-owned firms will not change. They'll be the same going forward. Contract awards. This is, I'm sure, what you're all waiting to hear about. Again, the injunction has said that it applies to administering the program. So we've determined that social disadvantage determination must be made for all individually owned firms before award can be made of an 8A contract. If you're already approved based upon a narrative, again, a non-group member who individually established his or her personal disadvantage, they do not need to again establish the disadvantage. That has been done. They're fine. There's been no basis of presumption in that case. Also, again, nothing new for entity-owned firms. Entity-owned firms can and still should be able to get contract awards in the 8A program without requiring anything additional. So the new questions are the narratives. You've heard about that. What should we do about that? As I said, going forward, agencies will not be able to award an 8A contract unless SPA has affirmatively found an individually owned firm to be socially disadvantaged. So all individually owned firms should start gearing up immediately. They should be thinking about what to do, how best to present their narrative, and have it ready for when it comes time for a contract award. SBA will soon put up on its knowledge base site some guidance of questions that will help you guide in your narrative until the questionnaire is actually changed. But when that happens, I think it'll happen in the next day or so. Certainly use that when you're preparing your document. SBA will also notify firms very soon how and where to submit this narrative. It's not going to go through your local BOS in your district office. It's going to come straight to the headquarters office, and they will then look at those determinations, affirmatively find you to be disadvantaged. There'll be a letter sent to you, and that letter you can then take with you when you're marketing procuring agencies to say, yes, I have been found socially disadvantaged. You can award to me without the presumption being in place, and you should be free to do so without any problems. So that would be helpful. However, as we know, there'll be awards coming up in the next week or 2 weeks, and maybe those questions aren't finally resolved at that point in time. What should you do? Well, and if you haven't, again, the narratives under the old system is the way to go. Start writing your narratives as we speak. There'll be questions. Again, the guidance on the knowledge base site will help you, but have that ready. And if an offering comes in on an 8A firm's behalf and they have not received a determination from SBA yet, as part of the acceptance process, we have 5 days to accept the requirement. Once it's offered to the program, we will do a social disadvantage determination within that 5-day period and try to accept the award within that time frame. Agencies should not be able to rely on SBA's inaction. We have partnership agreements with certain agencies right now, and those partnership agreements allow an agency to move forward if they haven't heard back from SBA within a certain amount of time. Regarding this new social disadvantage determination, they can't rely on SBA's inaction. They have to wait for SBA to affirmatively find a firm to be socially disadvantaged. So SBA's will be trying as hard as it can to meet the 5 days. If it runs over a day or so, that's possible. But again, we're going to try to make this as easy as possible for everyone. Agencies, be aware that SBA will be doing this across the board. We're trying to do it as many as possible. If we get hundreds at one time, it might slow us down a little bit, but we have a team ready and able to assist in assessing each firm's narrative that comes into us. Let's see. Oh, and in terms of a 8A competitive award, as you know, that's already SBA's. I'm sorry, procuring agency has authorized a competition. When they select the apparent successful offeror, they send that firm's name over to SBA for an eligibility determination. As part of that process going forward, SBA will also now firmly determine that the firm is socially disadvantaged. I'm sure we get a lot of contract questions also on existing contracts. How does this affect existing contracts? So what we're saying is that the injunction itself does not apply to existing 8A contracts. What does that mean? That means in-scope modifications and priced options can go on as before without any additional social disadvantage determination, without any problems. The authority for the option relates back to the initial award. The initial award was done under the rules at the time. That should be, there's no problem with that. So go forward with those unpriced options. I'm sorry, with the price options and with the in-scope mods. Unpriced options, as you know, SBA considers that to be a new contracting action. A new contracting action would require SBA's involvement, and that therefore the social disadvantage determination must be made with respect to an unpriced option. If the contracting action is under a previously awarded contract requires SBA's acceptance, then you must demonstrate social disadvantage. So what does that mean? So as you know, if it's a multiple award or a GWAC contract, that's not an 8A contract, but an agency wants to award a competitive task order under that contract, they have to offer that to SBA, and SBA has to accept it. So as part of that process, we would have to determine that the ultimate apparent successful offeror was in fact a socially disadvantaged firm. Similarly, even if it's an 8A multiple award contract or an 8A GWAC, if you're trying to do a sole source order, again, SBA requires acceptance of that order currently. Therefore, we would again require that particular firm to have demonstrated its personal social disadvantage in order for that order to go forward. That would mean, for example, like STARS 3. If you want to do a sole source order for STARS 3, you can do so, but we would require the social disadvantage determination prior to that order going forward. Finally, novations would be the same. So if by chance you were replacing one firm with another 8A firm on an 8A contract, we would require you to demonstrate social disadvantage before that novation could occur. I think that's basically everything I wanted to say. If there are some questions, Mark, have you seen questions that we should answer?
Lots of questions coming in about the contracting side, John, but I think you touched on every instance. We did have a question about applications that were accepted for processing and are in-house with SBA prior to the temporary pause on new applications. So can you just quickly maybe address what will happen to applications
Sure.
that are currently in-house?
So even though that the SBA had received an application prior to the July 19th order, we will require that those particular applications that are in-house to have the social disadvantage narrative or questions answered prior to being certified into the program. SBA is still processing the other aspects of the application, the ownership control questions, potential for success, all the rest, all the other requirements are still being processed as we go through the application, but we can't do the final you're into the program unless a social disadvantage determination is found. That'll be the case going forward, no matter when that was received.
John, it might be helpful to clarify that there's this determination of social disadvantage in connection with a contract award, specifically to address the contracting needs at the end of Q4 of FY23. But there's also going to be other opportunities for individual firms to demonstrate social disadvantage. Can you maybe touch on
Sure.
that?
Okay, so obviously, SBA will go out with a blast saying, get ready to do narratives with respect to individual contracts. If and we will prioritize those that for which an offer is pending or soon to be pending. But at the end of the fiscal year, if that has not happened, there are still 100, 200, 300, however many firms have not been certified by us. We would again do that at that point in time in the October timeframe to try to get everyone certified as a socially disadvantaged firm, so that they could then take that piece of paper that I talked about before and take it to procuring agencies when they're doing their marketing going forward.
John, a lot of questions about firms that already had a contract acceptance on their behalf. What is the process for firms that have already been deemed eligible for contract awards that haven't been awarded yet, sole source or competitive?
So the competitive, it will definitely apply to competitives, because no matter when that went into the system, the agency will have to come back to SBA and ask SBA for an eligibility determination with respect to that firm. So there's an action on SBA's part prior to award. Because there's an action on SBA's part prior to award, that award must be dependent upon a finding of social disadvantage by SBA. And with respect to sole source awards, SBA has already accepted into the program. There's no other action to be taken by SBA. There is some thought that we can go forward without requiring a social disadvantage determination. We also understand that certain agencies are a little skittish about that and may want to come back to SBA. That's their call. We SBA is not involved going forward generally with the sole source award at that point in time. So because SBA is not involved in going forward, we think it could go forward, but it's up to the agency to determine what's best for them.
How does this impact, John, individually owned applicants that were admitted to the program based upon a showing of individual social disadvantage prior to this ruling?
So as I said, it should not apply to them at all. They never benefit from the presumption, and SBA is enjoined only from using the presumption going forward in administering the program. And with regard to those firms never use the presumption. An award to them has nothing to do with the presumption, and we should be able to do that without any problem.
What about 8A contract awards to joint ventures?
So there is no joint venture admitted to the program, of course. So the joint venture's eligibility is based upon the underlying 8A firm's eligibility. If the underlying 8A firm is an individually owned firm that's seeking a new contract award, it would apply to that as well.
The number of questions, John, about entity-owned applications that were submitted prior to the decision, is there any impact on SBA's review?
There should not be.
Haley, Melissa, did I miss any big questions? There are a lot of questions kind of relating to the same 3 or 4 core topics, and I think John's hit on most of them, but did I miss anything that you saw?
Not from our end. It looks like you covered everything.
Okay. Well, thank you all for joining. This is very important to all of us. We certainly want the 8A program to work, to be successful, and we need your cooperation with us as we go through this process.
Yes, awesome. Thank you so much, John and Mark, for your time today. We really appreciate it. I know there's a lot of questions that people have, and we'll keep them updated as more information becomes available. A couple notes from our team. We're excited to announce our upcoming National Small Business Conference and Awards Gala in Atlanta this upcoming February. So make sure you head to our website. Registration did open this week for that, and early bird registration will only be available for a limited amount of time. If you do have additional questions, please feel free to reach out to our team, and we will connect with John and Mark to see if we can get your questions answered. But at this point, that's all that we have for you all today. Thank you again for joining us. This concludes today's webinar, and we hope that you'll join us next month. Have a great day.
Thanks.